Hey guys, welcome to my legal classes. This is Ganesh Pujari and we were discussing the essentials of valid contract, under which we were discussing the competent to contract. There are three types of personnel we have discussed, and in this video I am going to discuss in detail about the minor part of competent to contract. The next slide will be a fast forward slide because I have already discussed that slide in detail in my previous session. And I am going to discuss 17 important principles along with case laws as far as minor is concerned in this particular video. That is the very important aspect that you are going to learn after watching this video. With that, I am getting into my next slide, which is basically a fast forward slide. This slide is a familiar slide because we have already discussed this slide in detail in my previous session. However, I am just touch and go this slide in this session because we have already discussed. Now, there are three types of parties who are unable to enter into contract as per section number 11 and 12 of the Act. They are minor, or a person of unsound mind, or a person who is disqualified by law. I am going to focus only on minor, which is discussed under section number 11, which is all about who are competent to contract, which says who is of the age of majority according to the law to which he is subject. Now, it is saying to the law which he is subject. For all the citizens in India, for the age of majority, we are referring section 3 of the Indian Majority Act 1875. And as for that particular act, every person domiciled in India attains majority on the completion of 18 years of age. Now, one important aspect you need to remember that there are two exceptions for this majority age, that is 18 years, under the Guardian and Wards Act 1890. That act, that is Guardian and Wards Act 1890, says where a guardian of a minor person's or property is appointed under that particular act, or where minor's property has passed under the superintendence of the courts of wards. In such cases, the age of majority is considered as 21 years. Those are the two exceptions you need to remember. With that, I am taking you to the 17 principles about minors along with case laws. Now, let us try understand few important principles with case laws when it is coming to a contract signed by a minor. The first principle, which is discussing about the validity of a contract signed by minor. Guys, remember, the contract signed by minor is void ab initio. That means from the very beginning itself, the contract is not valid because he is not competent to contract. The second aspect you need to remember while discussing the void ab initio is that if such minor has gained any benefit because of such contract, the person who has signed such contract with the minor cannot ask those benefit back because the contract itself is void ab initio, and then he cannot also ask any kind of specific performance from such minor because it is void ab initio. This void ab initio is the one important term that you need to remember, and you have to explain that everything after that. That means if he has received any benefit or if there is any requirement of performance, nothing will come into picture because of this beautiful principle. There are two beautiful case laws as far as this beautiful principle is concerned, that is Moiri Bibi versus Dharmodas Ghosh and Mr. Sharma versus Mr. Nitin. In the first case, a minor took a mortgage loan of 20,000 rupees for 12% interest, and he could pay back rupees 8,000, and he couldn't pay back any further money along with the interest. Now, the person who has given the loan puts a case against such minor who has taken the mortgage loan. But the minor's mother fought a case saying that the contract was void ab initio. So the court also says that the person who has taken 20,000 rupees for 12% interest as a mortgage loan need not to pay anything back because he was a minor. That is one important aspect you need to remember because the contract was void ab initio. In the second case, that is Mr. Sharma versus Mr. Nitin, a 10th standard student takes a furniture worth of 5,000 rupees from a furniture seller saying that his father would pay for such furniture, but his father denies, saying that he will not make any such payment, and the person who has sold the furniture to a minor goes to the court, and the court says the contract is void ab initio, so the father need not to pay anything to the furniture seller because the contract was made between the furniture seller and a minor. So a contract with minor is void ab initio, so there is no responsibility to the father of minor to pay back the money. That's the important aspect discussed under Mr. Sharma versus Mr. Nitin. The second principle is minor's agreement can't be ratified. Ratification here means if you have signed a contract with minor, after he attaining the age of majority, you cannot say now it is ratified or it is a valid contract. That is not possible, which was discussed under Govindram versus Pirandita case. And the third principle is minor's parent or guardians are not liable to a minor's creditor for the breach of contract by the minor, which is what discussed again in Mohiri Bibi versus Dharmodas Ghosh or Mr. Sharma versus Mr. Nitin case. So you can take the example of those case laws here in third principle also. The fourth principle is minor can be a beneficiary under any contract. That is a valid contract unless and until any liability to the minor. Such contracts are valid because they are giving only benefits to the minor, which is what discussed under Sharafat Ali versus Noor Muhammad case. The fifth principle is contract for supply of necessities with a minor. Now imagine a case, Mr. A is a minor, Mr. X supports minor for all his education or religious requirement, food, clothes, bed, shelter, shoes, medicines, or if there is any funeral expenses of A's deceased family members or A's marriage expenses or any dependent female members, etc. In that case, those supplies can be asked back by Mr. X. Definitely yes, because those are the necessities supplied to a minor, and once A attains the age of major and when he starts working, he has to pay back to Mr. X because he has supplied the necessities, which is what discussed in one of the case laws where Kedarnath versus Ajudiya, where it was held that money advanced to a minor for a marriage is recoverable. The sixth principle says no estoppel against minor. It is very important for us to understand the meaning of estoppel. Estoppel means when one person by his words or acts or omission made another person believe a thing to be true and to act upon such belief, then such person who made to believe later on cannot deny his earlier representations. That is estoppel. But this principle is not applicable if the same has been done by minor, which is what held in the case of Sadiq Ali Khan versus Jay Kishore. The seventh principle is joint contract by minor and major. In all those contracts made jointly by a minor and major, the major will be held liable for all those contracts, which was held in the case of Sulochana versus Pandian Bank. What if a minor misrepresents himself as major and gains some benefit from a person, whether such minor is responsible or not, which is what discussed in Leslie versus Shield case. What happened here, a minor misrepresented his age as major and fraudulently took 400 pounds from a person. Now the court held that minor is not liable to repay any debt because the contract is void ab initio. The ninth principle is limited application of doctrine of restitution to a minor. Doctrine of restitution means if you have gained some benefit, you have to pay it back. But such doctrine is not completely applicable in the case of minor. That is one important principle you need to remember. But there are exceptions available under section number 13(9) to 41 of Specific Relief Act, and this principle is discussed under Jagannath Singh versus Lalita Prasad case. What if minor commits a tort? A minor is liable for all the tort that he has committed except for the tort committed via contract, because those contracts are void ab initio. Now let us understand few important provisions pertaining to minor and special contracts, and the first being partnership contracts. Benefits are applicable for the minor, whereas he cannot be liable for any terms of partnership contract. Agency contract, minor can be an agent, but he can't employ an agent or he can't be a principal. Now surety for a minor, if someone acts as a surety, in that case if minor fails to repay, surety will be liable. Minor as promisee, he can be promisee and he can draw, negotiate or endorse a negotiable instrument, but he doesn't incur liability. As far as guarantee is concerned, guarantee in favor of minor is valid. However, minor can't be held liable otherwise, and contract for the benefit of minor is valid. These are the important aspects you need to remember minor with special contracts. if there are any contract which are signed with the purpose of education or apprenticeship training, in that case those contracts are valid contract. That is one other important principle you need to remember. And if a minor want to become trade union member, in that case, if the trade union bylaws allow a person who is above 15 years to become the trade union member, in that case a minor can become the trade union member. That is another aspect you need to remember. And a marriage contract which came into existence for the benefit of the minor is a valid contract, and a minor cannot be declared as insolvent by any court because he is minor. And a minor cannot be a shareholder unless there is a guardian represents on his behalf, and burden of proving the minority is always on the person who has asserted such fact, and the benefit is always given to the minor. These are the few other principles. With that, I am concluding this particular video. My next presentation is all about soundness of mind. Thank you so much for watching me. All the very best for whatsoever purpose you are watching my video, and thanks again.